Ms. Nyla Kungiesingh. Nyla is a first-year law student and is from Trinidad and Tobago. She will be speaking on the topic of, should persons who leave Trinidad and Tobago to join Daesh be allowed entry back into this country? Let's welcome Nyla.
All protocols observed. Good morning, everyone. The topic I've been assigned to address today is, should persons who leave Trinidad and Tobago to join Daesh, also known as ISIS or ISIL, be allowed to return back to this country? The media has relabeled this jihadi extremist group several times since they began dominating headlines. But whatever their name, this group has presented the world with barbaric attacks, videos, and an unprecedented inflow of, according to the United Nations, 20,000 foreign recruits from over 100 countries, and as we all know, Trinidad is one on this list. My presentation today is divided into three parts, very simply: what we know, what we think we know, and what we should know. And hopefully, having done this, you would see why these persons should not be denied re-entry. What we know, the law. Trinidad and Tobago's Anti-Terrorism Act 2005 criminalizes any facilitation of terrorism. So solicitation, incitement, any promotion of terrorist activities. And just last week, the High Court in Trinidad considered this act, and for the first time, a national of Trinidad and Tobago was listed as a terrorist pursuant to Section 22B of the Act. In similar counter-terrorism legislation in the United Kingdom, which has been subject to more judicial consideration than the Act in Trinidad, the addition of a new feature is being considered: the imposition of exclusion orders to bar suspected fighters from entering. Now, such legislation does not criminalize something like recruitment or promotion of terrorist acts. Rather, it seeks to impose punishment on persons suspected of joining a group. Now, how the courts will interpret this, I am not sure. Whether they would look to the reasons why these persons went across there or false promises that were made to them by recruiters. But one thing is sure, that in considering the implementation of such legislation, we must consider exactly what this legislation is supposed to achieve. What we think we know, the purpose of preventing these persons from returning. The right to nationality is enshrined in Chapter 2 in our Constitution, in the Universal Declaration on Human Rights, and the 1954 Convention relating to the status of stateless persons, and many more conventions. Rights can be limited, we recognize this. But in order to derogate from rights, the threshold of severity and the principle of proportionality must be considered. Very simply, what would be the goal of this legislation, and how best can we accomplish this goal without eradicating the right altogether? The goal of this legislation obviously would be to prevent potentially radicalized persons from coming across here and performing terrorist acts. But this could easily be achieved through criminal legislation. Legislation should encourage citizens to return to face due process of law, rather than to force them to stay in a crisis zone and radicalize other persons. Now, as with any sensationalized issue like this one, there are things that we halfway across the world think we know but don't. And there is another goal here: to attempt to check the extremist narrative, which is the underlying cause of the ISIS situation. There's no shortcut to our security, and if we completely fetter freedom of expression on these issues, then these cancerous ideas would not go away. Rather, the disillusioned, angry young people that go there would just be pushed underground and would be separated from the mainstream ideas of nonviolence, and the overall objective that this legislation is trying to achieve would not be achieved. Thirdly, what we should know, the result of these actions, if they were to be implemented. If the government denies these persons re-entry, what we are talking about effectively is making someone stateless. Statelessness is the total destruction of the individual's status in organized society. More primitive than torture, it destroys for the individual his political and social existence. This is what the US Supreme Court had to say on this matter in deciding on rendering a person stateless based on national security in 1958. This is essentially what Britain and other countries are seeking to do today. Britain has now passed legislation that allows the government to strip terror suspects of their citizenship, even if it renders them stateless, so long as their citizenship is, quote, not conducive to the public good, or according to the British Citizenship Act, prejudicial to the vital interests of UK. What does this mean practically? That these persons would be prevented from legally residing anywhere in the world. Now, the rationale here might be that removing nationality would make it easier to deport them, but which country will accept a stateless person? Bringing the discussion to Trinidad, if the government chooses to render a person stateless, one could make the argument that based on the free movement initiative of CARICOM, the person would still be a national of CARICOM and could find refuge in another island. But this will further complicate the identity of these persons and make them even more vulnerable. Being a national of CARICOM without actually being a national of any CARICOM member state is a very complex issue. And I think that the discussion should not even have to go so far as if a person might have a chance of acquiring another nationality, they should be stripped of this nationality. Statelessness should not be about eligibility. To conclude, if we deny our nationals re-entry, they could float around CARICOM or go back to Turkey or back to Syria, but ISIS will still be there in the morning. This is a global issue, and if we wish to exist in a world that ISIS does not, then we cannot deny these persons re-entry into Trinidad and Tobago. Thank you very much for your time.